Hello, everybody, and welcome back. This is Chapter 5, the Leasing Process. So, if you are a landlord, you don't need a broker in order to rent out your property. If you already have a tenant, you can just go ahead and take care of everything on your own. However, most landlords will need a broker, especially a broker who understands the law. So, that is in a nutshell, why this course exists. Courses like the one I'm teaching right now are how the brokers will learn in order to pass the Rera exam. And the Rera exam was not mandatory for the past around 3 years for the pandemic, and many brokers don't understand the laws properly because of these relaxed regulations. I've also seen many times out in the field as a working broker people who were educated incorrectly by their brokers, people who are stuck in a terrible situation where they can't move into their property or they lost a lot of income on their property, they experienced damage to their property. I've experienced a lot of terrible things at the hands of people who don't understand the laws. So, everybody taking this course, I hope that by the end of this chapter, all of you brokers will be very educated on the laws and you are able to help landlords and tenants properly. And if you are a potential tenant, you will understand what are your rights and how to protect them. And you can be able to respond to anybody who is going to force you to do anything unlawful by telling them, no, this law, this amendment told me that I'm allowed to do this. These are my rights. And if you are a landlord or investor, you also will get a better picture on how the renting, how the world of renting really works and what you can expect. So this is a pretty important chapter, and I really hope that you pay very close attention. So a good broker can help a landlord in many ways. One of them is that for advertising the properties, they will usually cover the cost of the listings online. Property Finder, Bayut, and Dubizzle being the largest three. They will put the listing in high priority and they will list it for as long as the landlord wishes. The landlord usually does not pay out of pocket for this service. Usually the agent is paid by a commission from the tenant that they are able to get from listing this property. Also, once the property is listed online, they will receive a lot of calls from many people from around the world, and the broker will have the experience to filter out these calls and schedule viewings and show up to the viewings. So this will save the landlord a lot of time and frustration, worry, things like that. Also, when it comes to negotiations, the broker will understand the laws. They will understand you can't request this, or you can request this, but we might have to do that. Um, they can provide a lot of solutions based on their experience and from their knowledge of the law. Another thing that happens during negotiations is that finding a home to live in usually becomes a very emotional decision, and a broker who can stand in the middle of this discussion can prevent things from going downhill very fast. Usually there could be just one small misunderstanding, but it's going to cause bad blood between the two parties. The broker is in the middle and preventing either party from taking things too personally by telling them this is how it's been in the market and the landlord is not being unreasonable by asking this of you, provided the broker is somebody you trust. Also, the broker will take care of a lot of the paperwork. So this is something that as a landlord, it might not be obvious what is the paperwork that's required. Educating the tenant usually can be a time-consuming task to list out all the fees and all the schedules that they have to anticipate. So instead of making this an oversight, you can use a broker. So on to advertising. The listings should have information including what is the rental amount, how many checks do you want, what is the security deposit, is the unit furnished or unfurnished, how and when can the unit be accessed. So if the property is tenanted, there might be restrictions. So the current tenants might say, we can show you the property on the weekends, but somebody has to be home. Or the tenants might not allow viewings, and after the property is vacated, then they can do viewings. So you can list the property, and then tell all the potential tenants that, like all the potential people looking for a place to rent, you can tell them we will begin the viewings in a week's time or something like that. Although my experience with rental in Dubai is that properties are available for days or even one day. They can be taken very, very quickly. So it can be challenging, but rewarding at the same time. So, what is the desired starting date of the rental period and any other special conditions the landlord has? When a broker brings in a client for viewings, they should be aware if the client has an Emirates ID or if it's in the process. So they cannot register for Ijari or to move in without an Emirates ID. It's very important. And people moving into Dubai need to be aware from the beginning that they need this ID or they cannot find a place to rent. The broker should also tell the people viewing the property that they need to apply for move in with building management and how long that process takes, because it's not obvious. It's different for every country. In my home country, in Canada, I've moved into buildings where there is no special move-in form and waiting period like they have in Dubai, but you might wait a week or 2 weeks just to rent the service elevator. And then here in Dubai, it seems like you don't need to rent a service elevator depending on the building. So let them know what to expect so that they can plan out when they can move in and um, how much longer they should be staying in a hotel for, things like that. How can they access the building, key cards and entrances? What is the noise in the area? So that's very critical for some people. If they are living near a highway or a construction site, it can be very disruptive to the tenants, and we want everybody to win at the end of the day. What are the facilities they can use? So facilities in the building, the gym, pool, lounge, anything like that. Nearby amenities, if there's a gym or a beach nearby, it's very important to know. If you live in the Palm Jumeirah, you might be surprised to find that there's no grocery stores on the crescent or on the fronds. You have to go to the middle of the palm in order to do your shopping. Um, so those are some examples of facilities. If they have access to extra parking. So sometimes the building management can lease out parking spaces. Usually in Dubai, you can get parking quite easily, but in other cities, maybe there's no parking and there's no way you can get parking. So this can be a deal or no deal, a deal breaker situation for the clients who are viewing. And also, you should take note of the DUA number so that on the contract, on the rental contract, you can apply for Ijari and then immediately apply for DUA. And DUA is the um, electrical and water utility company. When it comes to making an offer, you should receive some specific information on how many checks, what is the rental amount, the start date, rental duration, which tends to be a year. But you can have 13, 14 months. You can have these things, provided that it's not in the short term category or long term category. You can negotiate a different type of duration. And then what is the security deposit amount? So let's say a landlord prefers one check. The client might be able to put an offer for 4 checks, but maybe they will offer a higher rental amount, something like that. So these are examples of offers. And now we have the Unified Tenancy Contract. This is available on Dubai Land's website, and it is universal. So everybody should be using this contract. I've experienced um, clients who've been confronted with a makeshift contract that doesn't match this one, just a document, and they were told to provide the security deposit, but they're not allowed to look at certain information or even know the name of the landlord. I've heard some clients receive some odd information from brokers, so this is very important for everybody to know. And if you are a landlord listing without a tenant, and you have without a broker and you have a tenant, you can use this form. So in terms of commission, there are some practices that are bound by the law and some that are just bound by the current economy and how things are done here in Dubai. So you must be a licensed broker, and the commission is paid on successful closing of the transaction or signing of the contract. So not before that. And the commission tends to be 5% of the cost of a 1-year lease. This isn't stated in any laws that it has to be 5%. It can be more or less. So it depends on the agreement that you make with the tenant, because the tenant is the one that is paying the commission right now. Currently, it's a seller's market. Um, Landlords have many choices for the tenant that they can have for their property. So the tenant tends to pay commission these days, but if things switch and it's a buyer's economy, if the landlords really just want to attract anybody to take their property and live there, maybe the landlord will be the one paying commission, depending on the changes in the market. So, ideally, the money should be received in a check that is paid to the brokerage. This money will be deposited immediately by the broker. They will usually split the commission with their brokerage, but I have seen people pay the money in cash. It's just preferred to use a check in order to secure the payments and make sure that there's no funny business going on. Now, the security deposit is quite a serious topic. Usually it's 5%, and this amount is held in reserve, so it's not rental income. And the landlord should return the security deposit upon the unit being handed over back to them. So the security deposit is in place to protect the landlord if the tenant fails to give adequate notice that they are leaving. So if they've agreed on 2 months or 3 months of notice, but the tenant gives less than that, the landlord can collect some of that rental income from the security deposit. If the tenant fails another type of obligation, let's say they've not return the unit in its original condition back to the landlord. If they've made modifications, the landlord can use the security deposit to fix these things, subject to normal wear and tear. So many white goods are not meant to last 10 years or 15 years, or they can't last that long without being serviced. So normal servicing is not something that the security deposit is meant to cover. If the tenant destroys the appliance, now that's not covered by normal wear and tear, and that can be taken from the security deposit. I know somebody who had his unit returned to him with the walls painted a new color. So this is not the original condition. Tenants around the world are aware that if you paint the property or you change the property without the landlord's permission, that you could lose your security deposit. So that's something that happened and caused a lot of conflict. But if the tenant was aware of the laws, they would not have tried to get away with that. I myself had a landlord try and take part of my security deposit for their maintenance. They said we normally need to spend some amount of money. It's not that much money. We need to spend some money to maintain the services that you've been using when you were living here. And I said no, because subject to normal wear and tear, I am returning this unit to you in its original condition, and maintenance fees are not my responsibility. That is the landlord's responsibility. So, in terms of selling properties, the landlord can transfer the deposit to the new landlord on the handover of the property. So, it becomes something that the new landlord will hold on to. But again, this is not an amount of money that they now possess. This is something that will be returned unless the cases that I've mentioned before. If the property is not returned in its original condition, and if the tenant does not breach any terms on the contract. Ijari is Arabic for my rent, And this was established by the this was created by Rera in 2010, and it can be done on Dubai Rest or in person at Ijari typing centers. If you go in person, you need to print out the documents. They need to see everything in hard copy, or you can do things electronically. This is the way for the government to keep track of rental agreements. You can keep track of trends in the market and all the units that are available for rent. It's very good in terms of protecting the landlord and the tenant, and it can resolve disputes much more easily by having a record of everything. So, Ijari is 215 to 220 dirhams typically, and usually by law, the owners are responsible for registering Ijari. However, the common practice today is that the tenant is the one registering the Ijari at the typing center or online. So why is this? Mainly it is because the owners are providing the information in order for the tenant to register the Ijari, so they still qualify as being the ones responsible. If they didn't provide the information, then they are failing to take the responsibility for Ijari to be registered. It didn't specify that the landlord is the one physically showing up to register for the Ijari. The tenants are also the ones paying the Ijari fee typically, and this is mostly due to the fact that it's a seller's market right now. The landlord could pay the fee if they are doing the registration, but it is a lot easier for the tenant to register the Ijari currently in terms of just the way that the common practice is, and also because the tenant will need the Ijari in order to register for DIWA, to sponsor their family, and to set up phone and internet. If the tenant is doing Ijari, they can have access immediately and they can do it on their schedule rather than waiting for the landlord to do it. So both options of the tenant or the landlord can register Ijari. I don't think that 220 dirhams is usually a deal breaker for either party. However, the common practice is that the tenant will do this, and that way the tenant can resolve all the things that they need to resolve in the time frame that they prefer. Cancellation of Ijari is 40 to 50 dirhams, and they must cancel Ijari before registering a new one. I had a broker when I first came to Dubai. When I asked him, can you have two Ijaris? He didn't know the answer to that. And it's very distressing when you're entering a new country and you've put a lot of money on the table to make an offer. You pay the first, I didn't pay the first check, but I gave the first check and I paid the commission and the security deposit. I felt like I've given so much money, and I'm asking these basic questions of about Ijari, and the broker didn't know. He just said, I think so. It should be like that. You can go and find out. Just go and find out. So instead of that happening, I'm telling you that you need to cancel your Ijari before you register a new one, which means you can't have two Ijaris on your name. For Ijari registration, you will need the Unified Tenancy Contract, the title deed, DIWA number, which usually this is located like on the property, right outside of the property. If you are an apartment building, it will be on the inside corner of your door. And if you are in a house, it can be right outside, maybe on your garage. The tenant's passport and the tenant's Emirates ID. So Emirates ID is mandatory for filling in Ijari. For commercial properties, you will also need a trade license or DED initial approval. And in terms of co-occupants, the Ijari is under the name of just one person, the Ijari holder, and they must register all their co-occupants who will be living with them for more than 1 month. This can be done on Dubai Rest. In 2002, the laws have changed in terms of allowing unmarried couples to be able to live together. So keep that in mind, that this is now possible. And for moving in, usually the property management will have their own move-in procedures. They typically need a copy of the Ijari and the Emirates ID. and they can take 24 to 48 hours to process the move-in. You might have to request a service elevator or maybe not, but this is something that has to be done with the property management company. And as a broker, it's important that you let the tenants know that this is an extra process and what the process is for each building that you are working with, because every building will have different rules. So property management is paid for by service fees. This is the landlord's responsibility. And this is covered in section 4 on section 3 on jointly owned properties that I've already covered. Jointly owned properties being common areas like the pool, the lounge, the gym. These are all owned collectively by all the owners in the property, and they must pay for the maintenance and usage of these services with service charges. So this is something that the landlord is responsible for and not the tenant. I've added here also that if you are an agent and there is renewal on a contract, you will not receive commission for that because you're not really doing anything extra. This renewal is something that the landlord and the tenant will work on together. If they ask the agent to do the paperwork on their behalf, the agent or the brokerage might be requesting a 500 dirhams administration fee, for example. It doesn't have to be 500 dirhams. It could be any other amount that they request. But the agent is not entitled to commission on renewals. Now, what are the landlord's obligations? The landlord cannot carry alterations to the premises or any services, or else he or she will be liable for damages that are caused, faults, or shortages to premises. So, if the landlord decides to change the water pipes and the tenant cannot access the water for a long period of time, this is in breach of the landlord's obligations. In any kind of breach, the tenant can go to the RDC, the Rental Dispute Committee. This is the legal body that's responsible for all the tenant disputes. So, on handover, the property must be provided in good condition that the tenant is ready to occupy and enjoy. So I have some experiences with landlords in another country, but it's very similar in terms of the law that the property was not available. The landlord began renovations months in advance of the move-in date, but then they couldn't finish on time, and they told the tenants, okay, you can move in, but next week. And the renovations kept getting delayed again and again, and the tenants were living on their friends' couches until they can move in, and it was delayed over 3 weeks by the time they took legal action against the landlord. But you are allowed to take action well in advance of that. The landlord is also responsible for and must rectify defects or damage that affects the tenant's intended use of the property. So this basically means large structural changes and big maintenance is the landlord's responsibility. The landlord is prohibited from disconnecting services or obstructing the tenants from occupying the property. If you are a tenant, you are allowed to evict your tenants, but you cannot do this physically. As you can imagine, it's going to cause a lot of problems. You don't want to end up with a police report against you for blocking someone from entering their property. That is going to put the landlord at fault, even if the tenant broke the laws in order to stay in the property. If you want to evict your tenant, I will be covering that in the next few slides. As a tenant, your obligations include paying on the due dates, not making alterations or doing your own maintenance work on the property, returning the property in good condition, as in its original condition, subject to wear and tear. You cannot remove any fixtures, unless it is agreed upon between the tenant and the landlord, and you also are responsible for the utility fees. So, the security deposit, as I've already mentioned, I just want to mention again to make sure nobody is confused. It is paid in advance and held in reserve. It will cover the loss of rent, damage to premises. It also includes lost security keys and repairs that are not wear and tear. So keep that in mind. Now let's talk about eviction. So this is something that I've come across many, many times, and it's been approached incorrectly most of the time. So landlords want to evict their tenants in order to attract a new tenant, in order to collect more rental income. However, based on the law, this is not possible. Tenants have an automatic right to renew, and it doesn't matter if the landlord tries to write a clause on the tenancy contract, or even if the tenant signs this contract saying, yes, I will not renew. It doesn't matter what is written on the contract because the law will always prevail and it is not enforceable. The tenant can go to the RDC and protect their rights to renew the contract. Or they could claim reimbursement for the wrongful eviction from the property. So, if you are interested in evicting your tenant to collect more rental income, just understand that you can't. So, there are only 3 reasons why you can evict your tenant. One of them is that you are moving into the property yourself, or a direct relative will be. You will be selling your property, or you are conducting major repairs and renovations that cannot be done with a tenant living there. So this is related to the landlord obligations, that if you do maintenance work and it affects your tenant, then you should evict them in order to do the maintenance work. So if you want to serve this eviction, it has to be given with a 1-year notice period, and it must be done either by registered mail or notary public, and the tenant receipt is required. You cannot claim that you gave the notice period, but the tenant didn't receive it. That doesn't work in the courts. The tenant has to receive it. You also cannot list your property for rent within 2 years of evicting your tenant. And if it's a commercial property, the limit is 3 years. In the case that the landlord wants to evict the tenant for them to move in themselves or a direct relative, there are additional restrictions, which is that if the landlord has a comparable property that's vacant, then the courts will be wondering, why don't you move into that one? Why do you have to move into this one? So the landlord needs to be very careful if they are trying to evict a tenant for the wrong reasons and trying to use some of these excuses in order to do that legally. Okay, so this is something I see very often. Of course, the landlord can list the property again down the line in the future. But if the tenant is evicted and they realize that the landlord didn't evict them legally, if the landlord put the property back online to find a new tenant, the previous tenant is allowed to file a case with the RDC, the Rental Dispute Center, and I will talk about that later. But there are definitely scenarios where the landlord has a right to evict the tenant if the tenant is really doing something wrong. So if the tenant fails to pay the rent, or if they breach another rental term, the landlord will give 30 days notice for eviction. If the tenant is doing something illegal, they're using the property illegally, such as using a residential property for commercial uses, or if they are committing crimes, if the tenant is subleasing without the landlord's approval, if they've made dangerous alterations to the property. On the right, I have a picture of a hoarded house, so that's an example of something that makes the property dangerous. If you are renting a commercial property, you cannot leave your unit vacant for a period of 30 continuous days or 90 non-continuous days in a year. The reason for that is that empty commercial properties look um, really bad. They make it look like the area has been neglected and it's going to impact rental income for everybody in the area. So that's one of the reasons why you have to occupy the commercial space. Another reason for getting immediately evicted can be shisha smoking or smoking, barbecuing on the property, having pets if it's a no pet friendly, no pet zone, and even hanging clothing off the balcony, because that can be a major violation in terms of just safety. Clothing is not secured when it's hung from the balcony. So these are legal ways to evict without having to send a 1 year notice and things like that. If the tenant is doing any of these things, you can evict in 30 days or immediately. So, eviction for short term rentals is going to be different from what I've just outlined. Landlords certainly have rights. It was a typo here that you cannot evict, but you certainly will have rights. It's just that this is something that is very tightly regulated with a completely different rule book and a different um, committee in charge of regulating short term rentals. So it's better to ask somebody who is specialized in short term rentals on what you can do. And this is not something that most brokers are trained in. Eviction can also be canceled with a written notice. So that's good to know. Um, And in terms of enforcing the eviction, if the tenant refuses to evict, the landlord cannot evict the tenants forcefully. They can't just disconnect the DIWA and force the tenants to leave by stopping them from entering the property again or canceling their key cards. The landlord cannot take the matters into their own hands. Things can get very messy and they can get very dangerous too. So, what they need to do is go to the RDC and get a court judgment. If the tenant fails to respond to this, the landlord can then call the police. The police will handle the eviction. You don't want to just call the police immediately. You don't want to give the tenant 12 months notice and they're not evicting, so just call the police immediately. You don't want to do that because the police will probably advise you to go to the RDC for the RDC's judgment on the matter. The police cannot make the judgment on who should be evicted. If the police sees that there is already a court judgment and the tenant has failed to reply in the amount of time that they're supposed to reply, then they can take action. So keep that in mind as well. Um, a good broker will educate investors on the worst case scenario and best practices. All right, so that is something very, very important. This is the reason why brokers enter real estate, because they love properties and they love helping people. So you must understand these laws as a broker in order to help your clients, because as you can see, we're talking about something escalating to the level of danger and something that could cause physical harm to you if you are not enacting your rights properly, and even police involvement. So this is quite serious, and that's the one of the reasons why it's also important, if you are a landlord or a tenant, to have brokers that you can trust. Now, the RDC, which I've mentioned many times, stands for the Rental Dispute Center. It's located in Rera, and it is existing for both landlord and tenant protection. So, the RDC will always follow the law. It doesn't matter what was written and signed by either party. The law will always prevail. The decisions that results from the disputes usually are involving financial compensation for wrongful eviction if you are a tenant, and if you are a landlord, the RDC will give you legal assistance to evict your tenant. So if you are in a situation where you have to file a case with the RDC, take note that the RDC will try to resolve all the cases within 75 days. You also need to provide the original lease, proof of payment, so if you have checks, provide those, Ijari registration, and any DIWA bills. If you had to get a new lease because you were wrongfully evicted, then you should provide an offer and deposit that you made on a new property, in addition to any other checks you might have written. You should also provide your passport, Emirates ID, and title deed. And also, pay a fee of 3.5% of the lease amount. You also will fill in an application form, and then the landlord will have typically 15 days to respond. If a tenant did not pay rent on the property, they can be subject to a travel ban. So if you want the ban to be lifted, you have to pay the rent, and then within 5 minutes, you can have the travel ban lifted and you can fly. So you have no excuses, pay the rent. Now, this is an extremely useful government service, a rental good conduct certificate. If you are a tenant or a landlord, you can search the person that you will be signing a lease with to see if they have any previous cases with the RDC. Of course, having a case doesn't necessarily mean that they are guilty, but you should be aware that if somebody has many cases filed against them, or if the cases are very severe and they are guilty, this can help you make your decisions. So for subleasing, this is typically not the broker's responsibility. The property management will take care of things like this. The landlord will need to consent to subleasing with a written contract, and the contract will continue with the subleased tenant if the primary tenant leaves. So what that means is if I'm the tenant and I'm looking to sublet my unit, if I'm away for half the year, for example, and I want someone else to live in the property, and the sublease tenant decides that they want to stay in the property after I decide that after the end of the contract, I want to leave, then the subtenant can stay. This, of course, needs to be all written out in a contract so that nobody's confused and the subtenant doesn't become an unwitting or unwilling squatter. So if the primary tenant subleases without permission, then both the tenants will be evicted and the subtenant can file a claim against the primary tenant. So they can go to the RDC and they can say that I was told that I had permission to rent in this property. I've been paying rent, and turns out that we were both evicted on immediate notice, and I had to lose these resources. I had no choice. I had nowhere to live. I had to stay in a hotel, something like that. So subleasing is legal, but under certain restrictions. Now, the rental increase cap was introduced in 2013. The landlord will need to provide 90 days of notice period. And this can be given informally. They can just write a WhatsApp to say, I'm going to increase the rent to this amount. And the tenant must acknowledge that the rental will increase. So the landlord can't say, well, I sent them a WhatsApp, but the message didn't go through. I don't know. Maybe they didn't get the message. No, they have to have received the message. And the rental increase cap is the law and it cannot be superseded. There are situations where landlords think, or they've been wrongly guided to think, that they can do a valuation on the property. So the valuation will tell them, well, your property is worth 120,000 in rent, let's just say. And the landlord will think that this means they can increase the rent because a valuator told them that's how much they can get. That's not true. They still have to follow the rental increase cap. If they have any vacant units and they were not sure how much rent to charge, that's where they can apply the amount given by the valuator. So you should know your rights. Here's a list of some of the laws and where you can find them. So the RDC website will have a lot of useful information for you. The Smart Judge app can also help you in your disputes. Law 26 of 2007 regulates the relationship between landlords and tenants. Law 33 of 2008 amends Law 26. And Law 43 of 2013 determines the rental increase for property. So that's the rental increase cap. Short-term rentals are managed by the DTCM, the Dubai Tourism and Commerce Marketing. So they will operate similarly to a hotel. You will need to pay tourist tax and VAT. You will need to provide fresh linens and cleaning in between guests. You also need to provide the exact amount of resources that matches the occupancy. So if the occupancy is 4, you need to have dishware and cutlery for 4 people. You also need to provide all the things in the unit so that the person can use it comfortably as if it's a hotel. And if you don't comply, there is a fine up to 100,000 dirhams. So this is very challenging. There is actually quite a lot of rules, and it's very easy um, to lose your license. So keep that in mind. So now we have a quiz. I covered questions 1 to 14 at the end of chapter 2. And this quiz will be covering the content from chapter 3, 4, and now 5. So these are questions that I've written in order to help you assimilate the knowledge that I've taught. It's also based on a Rera exam that I've taken and those that I've encountered or heard of through other people. So let's begin. Question 15. The landlord may evict a tenant legally to sell his property in time within 6-month notice given in registered mail. A. True. B. False. 16. The landlord may evict the tenant with what time period in order to move into the property himself? A. Immediate. B. 30 days. C. 90 days. D. 6 months. E. 12 months. Question 17. The landlord may evict the tenant with what time period for failure to pay rent? A. Immediate. B. 30 days. C. 90 days. D. 6 months. E. 12 months. 18. How much are the fees for valuation of empty land? A. No fees. B. 1,000 dirhams. C. 2,000 dirhams. D. 5,000 dirhams. E. 20,000 dirhams. 19. Is a non-renewable lease clause after the initial 1-year term enforceable? Let me just say that again. Is a non-renewable lease clause after the initial 1-year term enforceable? A. Yes, a lease is non-renewable. B. Yes, if the tenant signs the contract with these terms. C. No, a lease is always renewable in accordance with the law. 20. Which properties are exempt from the rental increase cap? A. No properties in Dubai are exempt, including free zones. B. No properties in Dubai are exempt, excluding free zones. C. No properties in the UAE. D. Only free zone properties are affected. 21. If the landlord fails to pay the service charges for jointly owned property, he may sell the property and attach the payment as condition for sale for the new landlord. A. Correct. B. Incorrect. 22. How long are checks valid for in Dubai? A. 1 month. B. 6 months. C. 12 months. D. 18 months. 23. A non-GCC national can own properties in designated areas only. A. Correct. B. Incorrect. 24. Developers are responsible for repairing fixtures such as mechanical, electrical, sanitary, and sewage-related fixtures in projects after handover for a period of 1 year. A. Correct. B. Incorrect. 25. If the property has less than 60% completion and the owner fails to make the payments, how much can the developer keep in terms of percentage of sale price? A. 10%. B. 20%. C. 25%. D. 40%. E. 60%. 26. The Golden Visa application can be done at the Cube Center at DLD. A. Correct. B. Incorrect. 27. Which institution is in charge of the unpaid service charges from property owners? A. Dubai Courts. B. DIFC. C. DLD. D. RDC. E. Dubai Police. 28. Brokers practicing without a license can be subject to a fine by the DLD of A. 50,000 dirhams, B. 100,000 dirhams, C. 150,000 dirhams, and D. 200,000 dirhams. 29. Landlords conducting short-term rental without a permit from DTCM can be subject to a fine of A. 50,000 dirhams, B. 100,000 dirhams, C. 150,000 dirhams, and D. 200,000 dirhams. 30. What is a subdeveloper in the real estate industry? A. A person who is licensed to conduct real property development and to sell real property to others. B. A person who undertakes part of a real property development of a master developer upon agreement between them. C. A person who is licensed to demolish properties in all zones. D. None of the above. 31. In off-plan sales, who takes responsibility for registering the sale? A. Buyer. B. Developer. C. Dubai Land Department. D. None of the above. 32. Who can you contact to report a broker for illegal conduct? A. Rental Dispute Center. B. Dubai Land Department, Real Estate Violation System. C. Dubai Police. D. None of the above. 33. Who is covered under the Dubai Land Department RVS system? A. Licensed brokers. B. Brokerage offices. C. Property management offices. D. Real estate developers. E. All of the above. 34. The Dubai Land Department inspects the projects every 3 months and subsequently releases part of the payments from the escrow account. A. True. B. False. 35. The investor cannot take action on delayed projects, including filing a lawsuit against the developer, even if they had upheld their agreement in the contract. A. True. B. False. 36. You can inquire on the owner of a title deed from the Dubai Land Department, to whom it may concern, for a fee of A. No fee. B. 50 dirhams plus knowledge and innovation fees. C. 120 dirhams plus knowledge and innovation fees. D. 2,000 dirhams plus knowledge and innovation fees. 37. Can a Rera certified broker advertise projects in the UK without a permit? A. Yes. B. No. C. It depends on POA. 38. The owner sends a request for NOC to the property developer in order to sell the property. A. No. It is the responsibility of the buyer. B. Yes. C. No. It is the responsibility of the developer. 39. Which type of residence will typically have a higher service charge per square meter? A. Residential unit. B. Residential villa. C. They are about the same. 40. Does the developer track off-plan properties that are sold to a new owner? A. Yes, the system automatically updates. B. Yes, because the developer issued the NOC. C. Yes, because the management company uses the Malak to see changes. D. No, the resale of units is not of importance to the developer. 41. What does SPA stand for? A. Sole Purchase Agreement. B. Supplier Purchase Agreement. C. Summary Purchase Agreement. D. Sale Purchase Agreement. Okay, so now it's time to get the answers. For question 15, the answer is false. The notice period is 12 months by registered mail or notary. For question 16, the answer is 12 months, same as previous. For question 17, the answer is 30 days notice. For question 18, the fees are 2,000 dirhams. Unfortunately, you might have to memorize that, but empty land will be more straightforward than a land with a property on it. Notice that there wasn't a size indicated. Question 19, the answer is no. A lease is always renewable in accordance with the law. As I've said before, it doesn't matter if the tenant signed the contract, the law will always prevail. Question 20. The answer is A. No properties in Dubai are exempt, including free zones. 21. The answer is B. Incorrect. If the landlord fails to pay the service charges, they cannot sell the property. So the new landlord is not responsible for paying the previous service charges by the previous landlord. Question 22. Checks are valid for 6 months. Answer is B. Question number 23. Correct. A non-GCC national can own properties in designated areas only, also known as free zone. Question 24. The answer is correct. The developers are responsible for fixtures such as mechanical, electrical, sanitary, and sewage-related fixtures for a period of 1 year. Question 25. The answer is C. The developer can keep 25% of the sale price. Question number 26, the answer is correct. You can go to the Cube Center at DLD for your golden visa. Question number 27, the answer is RDC. You can resolve the unpaid service charges through the RDC, the Rental Dispute Center. Question number 28. Brokers practicing without a license are subject to a fine by the DLD of 50,000 dirhams. 29. Landlords who are conducting short-term rental without a permit can be subject to a fine of 100,000 dirhams. The answer is B. Question 30. A subdeveloper is B. A person who undertakes part of a real property development of a master developer under agreement between them. Question 31. B. The developer is responsible for registering the sale. Question 32. You can contact the Dubai Land Department Real Estate Violation System for reporting a broker for illegal conduct. Question 33. Who is covered under the Dubai Land Department RVS system? The answer is E, all of the above. Question 34. The DLD inspects projects every 3 months. Answer is A, true. 35. The investor cannot take action on delayed projects, including filing a lawsuit against the developer, even if they've upheld their agreement in the contract. The answer is false. They can take action against the developer. If they have not upheld their end of the contract, then they need to fulfill their obligations on the contract before filing a lawsuit. but they have the right to file a lawsuit. Question 36. The answer is B, 50 dirhams plus knowledge and innovation fees. So the key here is that you got it from the DLD. The charges are 50, but if you got it from a registration trustee, it is 120. Question 37. Can a Rera certified broker advertise projects in the UK without a permit? The answer is B, no. Question 38. If the owner sends a request for NOC to the property, the owner sends a request for NOC to the property developer in order to sell the property. B, yes. You need to request an NOC to sell the property. Question 39. Which type of residence typically has a higher service charge per square meter? The answer is A, residential unit. So typically they are smaller, the joint area is larger for the number of people, and they will have a higher service charge. So question 40, the answer is A. The system automatically updates when an off-plan property is sold to a new owner. Question 41, SPA stands for D, Sales Purchase Agreement. And that's it. That was a lot of questions. That was a little bit tiring for me, but I hope that is great practice for you. It took certainly a much longer time to write the questions as it did to read them out loud. And the important thing is that you learn. So hope you learned a lot today, and see you back for the next chapter.